Yes, Ms.
Thank you, Chair. Chair, before we continue with the witness this afternoon, Advocate Johnson has made a request to us as evidence leaders, which request I table to the commissioners for consideration. Advocate Johnson has requested that we sit until 4, but may she be excused at 3 this afternoon. She's, as the Chair is aware, currently on medication following her illness last week. And I'm made to understand that the medication she's on is having some debilitating effect on her. So she has requested an early stand down today at 3 o'clock.
I confirm that, Chair. There was that communicated to me by Ms. Johnson. I communicated it to Ms. Sello, and that's where we are. Thank you.
Thank you, Ms. Sello. Thank you, Mr. Bodlani. We will adjourn at 3 p.m. then.
Thank you, Chair.
Thank you.
Ms. Johnson, then we have an hour to run through some of the issues we had wanted to engage you with on today. I hope you feel better tomorrow.
Thank you, and thank you, Chair.
Thank you. We had just looked at the affidavit and its compliance or the lack thereof with Section 27. So now we're at a point where you are in receipt of this affidavit. Can you take the commissioners through every step you took regarding this affidavit, any discussions you had, and with whom, until the point of the 6th of December, when you say you took a decision to refer the matter for a preliminary investigation? Thank you.
Maybe before you do that, let's remember earlier we discussed that after you received the letter, you from the minister's office, you then spoke to Mr. Perumal.
Correct.
Who then took it from there. Now, when Mr. Perumal, after you speak to him and he takes it from there, does he come back to you to say anything before we get to this point of the Section 27 affidavit?
Commissioner Baloy, what he does come back and say, the gist of which is he has communicated with Mr. Adams. Mr. Adams indicated that he had reported these 4 dockets that we see in the letter. He informed Mr. Adams that as per Idac, if you want Idac to look at a matter, you would have to depose to a Section 27 affidavit. He told him it would be best if he maybe sat with a legal representative, told him where to find the provisions of Section 27, and for him to then, should he still be of a mind, to then depose to an affidavit. That is where that part stopped. And then on the 21st of November, we were in fact then furnished with the Section 27 referral, which is currently in the doc, at least part of the bundle.
Okay, thank you. Then back to Ms. Sello's question then.
Thank you, Commissioner.
Perhaps for my benefit as well, please.
Absolutely. The question was, we have just very quickly looked at the contents of Section 27 affidavit. And as I understand from the witness's testimony, she has seen it and perhaps has engaged with the affidavit. We are aware that on the 6th of December 2024, she took a decision to initiate a preliminary investigation based on the affidavit. So I would like her to inform the commissioners of the steps she took subsequent to the receipt and consideration of this affidavit up until she took that decision.
Thank you. May I find out if you will be dealing with his reason to suspect at some stage? I'm not pushing you there, not now.
Yes.
His reason to suspect in 28(1)(a) at some stage?
Yes.
All right.
I intend to do so.
Thank you. Thank you. Please respond to the question, Ms. Johnson.
Thank you, Chair. I received the Section 27 referral. Once I received the referral, I myself perused the referral. I then decided to give the referral to the team of Advocate Manilal. At the time, I can't recall where he was, but I gave it to the advocate in his team, which is Advocate Ramsamy. The purpose is, as was explained previously, that once you allocate it to a team, commissioners, they would then peruse, see whether there's sufficiency, what next steps must flow. Ms. Ramsamy, Advocate Ramsamy then perused the Section 27 and brought a Section 2813 application. And the purpose, sorry.
Can I just interrupt you before you speak to the purpose? You haven't said anything about Mr. Sissoko. Is it
That is
because
correct.
At that time he's not featured?
It's not featured, and because this was really, some of the 27s are really voluminous, and I like that two-mind approach. This was just a small document where I could quickly apply my mind. And I looked at it and said, let me give it to a team as we would then ordinarily do, because on the face of it, there were offenses that fell within the mandate. I gave it to Advocate Ramsamy, who then perused the Section 27. She realized that there were references made to dockets, and because we didn't have those dockets, the best way, instead of asking Mr. Adams to amplify the 27, as one would ordinarily have done, is to first get these dockets, because he's talking to allegations in these dockets and he makes reference thereto. So in order to get those, sorry, Counsel.
No, please proceed. No, never mind me.
No.
No, continue. I don't intend to interrupt at all.
Okay.
Thank you.
And in doing that, she applied for a Section 2813, which is a preliminary investigation, on the 6th of December. It was a mechanism, commissioners, for us to then have an authorized investigation in order for us to now determine where these dockets were. Bearing in mind that Mr. Adams has already alluded to the fact that in Cape Town, these dockets were no longer there. He makes allegations. But he then says he opened dockets in Gauteng. So there's no need for us to go to Cape Town. If you opened similar dockets in Gauteng, we engage then with detectives in Gauteng. It would have been one of the investigators, it would either have been Mr. Perumal or Mr. Rapeso, who indicated that we need to write a letter to the head of the detectives in Gauteng, who was a Major General Khumalo. It is a formal approach in terms of acquiring those dockets. I did pen a letter under my hand to the Major General, indicating that Idac was now vested with an investigation and would require the dockets as per the letter, which were the dockets that were referred to in the minister's letter and subsequently by Mr. Adams.
And by this stage, you have now made a decision that Idac is investigating this matter. By the time you are now asking for dockets.
A preliminary investigation, yes.
Okay.
And a preliminary investigation, if I may, is it might pan out to nothing. That is why it is safer to have done a preliminary investigation, because not knowing what's in the dockets, it could be a futile exercise having a full investigation, using all of the time and resources, and find that actually it's insubstantial to support.
And you did this in terms of Section 2813.
1.3, Chair.
Section
Yes.
2813. All right, thank you.
Thank you, Chair. In the morning, I'd understood that your approach to the head of detectives, I think you said General Khumalo,
Major General
Khumalo, was requesting the dockets was on the 6th of December.
That is correct.
That is the same day a decision was taken to authorize a preliminary
That is
investigation. So it can be on the 6th of December that Advocate Ramsamy made an application, because you're only making a decision on the 6th of September to initiate at 2813 in preliminary investigation.
The authorization was dated the 6th.
That's your authorization.
My authorization. She would have given me the papers prior. I just can't tell you which day prior to the 6th.
What papers would she have given you in this regard?
So it is an application for an authorization, which the ID must consider to approve. So she wouldn't have given it to me on the day to approve on the day.
So at the time she gives you whatever application she does, what is she armed with?
She would have been armed with the Section 27.
She also, at least she got a copy.
She had the 27.
Okay.
Yes, ma'am.
Now, I think it was yesterday or this morning, I came to understand, and maybe I was wrong in my understanding, that prior to the 6th, you and Mr. Sissoko, I thought you said, engaged extensively over this Section 27 affidavit, on the basis of which you then took the decision you did on the 6th of December. Now, in the narrative you just provided, you haven't said anything about your engagements with Mr. Sissoko.
The chair did ask earlier. I said in most of them, I would engage with Mr. Sissoko. This was a very small Section 27. I don't have to give him. It is a practice I do, and usually with the more bulky ones. They have been on the off case or off chance where it's really a small, not small, it's not nice to say small. It might not be substantial, and I am able to go through it myself, apply my mind, and make a decision.
So are you suggesting my understanding all this time has been wrong, that you engaged with Mr. Sissoko on this particular referral? Because that's what I had understood from your testimony.
I didn't engage him on this referral.
It's not, Ms. Law, it's not a misunderstanding. It's what you said throughout, that you did consult with him. If you recall, even yesterday when I said to you that Colonel Parayaki spoke of a committee, an intake committee, and you said, well, on paper we have it, but we haven't yet implemented it. And so what I do, this is what you said, what I do is I receive it, I consider it, I form a view, I give to Sissoko, and he then took that into account and he came back to me and we agreed that this falls within our mandate. That was your testimony yesterday. So it's not a case of misunderstanding. It's you are revising what you said to us yesterday.
Sorry, if I created the wrong I meant when we talked about the intake committee, I was trying to explain that there is no committee, how the Section 27s worked. So if I created that impression or it's incorrect, I did not share the Section 27 with Mr. Sissoko.
So too then was Colonel Padiachi wrong in testifying that the briefing was given to the team by Chief Perumal after the case management committee had considered the Section 27. That's utterly wrong.
No, that's wrong.
Because you are not a committee, you are one person.
We are not a committee.
Yes.
And sorry, Chair, I did indicate yesterday, there is no committee, and I cannot call Mr. Sissoko and I a committee. I give it to him because he's an investigator, and with me being a prosecutor, it helps that perspective. But there is no committee at the moment that deals with any of the 27s as they come in.
And it might be a speculation on your part, but what could possibly have led Colonel Padiachi to conclude that the investigation referred to the team was following a decision by a committee? What could have?
I think I alluded to yesterday that we, in the process of putting together a draft standard operating procedure manual. It is one of the things that is proposed in the manual, but it is not implemented currently or in effect.
Okay.
I think I did a note to that yesterday.
So please have regard then to Section 27. Seeing as you are the person who received the Section 27 referral, who considered it, I think now we, at that point, the question the chair wanted to engage you on, is it correct to say that on your reading of that affidavit, you considered that there were reasonable grounds to proceed with this investigation?
Correct.
That's what you consider. On what basis?
There were reasonable grounds for us to consider the matter based on the allegations made out.
Just the suspicions.
Just
and
the reasonable
more.
suspicions.
And at that juncture, you had nothing but the Section 27.
That is correct.
And then if we go to Section 28:13, that section provides, if the investigating director considers it necessary to hear evidence in order to enable him or her to determine if there are reasonable grounds to conduct an investigation in terms of subsection 1A, the investigating director may hold a preparatory investigation. So by this point, you had, based on just the affidavit, you considered necessary to hear evidence on these suspicions.
That is correct. And the hear evidence is not of necessity oral evidence. It's getting the evidence to support, if there is, in fact, to support those reasonable grounds.
What do you make of the word "here"? Open quote "here", hear evidence. What do you make of just that word "here"?
Is the conducting of the interview with the witnesses, prospective witnesses.
And thank you, Chair.
And that would be a formal process, a recorded process.
It
Those
can
interviews.
be a recorded process, yes. More often than not, the 28s are a recorded process, or it is an interview process,
Yes.
and then the statement is taken.
Yeah, but what I'm asking is, in what happened in that interview, there must be a record of it.
There should be a record of it, yes.
On this day, so-and-so met with Mr. Adams at Pretoria from this time to that time. This is what was discussed. Yes, it will culminate in a statement, but there is a record of,
There should be a
of
recording,
what
yes.
happened. Thank you.
Yes.
And you know this for a fact.
I'm saying-
Sorry, just a minute. We don't want you going back on what you've just said in response to my colleague, Commissioner Madlanga.
I did say, Chair, there should be a recording. I will confirm that whether or not there was a recording.
When you say there should be, are you referring to this instance, or are you saying there should be a recording generally as a general statement?
In these matters, generally there is a recording.
So there is a recording.
A recording, yes.
As a matter of course.
As a matter of course.
There is a recording.
Yes.
All right. May I just ask one?
Absolutely, Chair. Thank you.
The Section 28:13 hearing of evidence, let me loosely call it that. Surely that the need for that does not undo the requirements of Section 27. Section 27 must have been satisfied. The requirements of 27 must have been satisfied. You cannot, if the affidavit does not meet those requirements, you cannot get to 28:13. Is that correct? Do you agree?
That is correct, Chair.
Thank you. So basically, as you would have learnt in your administrative law, those are the jurisdictional facts for, or to trigger anything that gets done under 28.
Correct.
Those are the jurisdictional facts.
Correct.
Thank you.
Just one from me. To To hear evidence under subsection 13, do you have to summon the witnesses who are going to give that evidence? Do you have to issue a summons to Mr. Adams, for example? How do you hear the evidence in the absence of a summons?
There are oftentimes, Commissioner Khumalo, where you contact the person and they are prepared to come in, or where they do not want to come in, then you do issue the summons in terms of Section 28.
So in this specific case, what happened?
In this specific case, Mr. Adams was contacted, he was prepared to cooperate, and the investigators and a prosecutor then went ahead to interview him.
Now it works. Now it works. Ms. Johnson, can we have a record of that section 2813 process that you say happened? Can we just have a complete record of that?
For this?
Yes, that 2813 process.
That would have happened with Adams in January.
Yes, thank you.
Thank you, commissioners. So, I think earlier, oh, sorry. She's still writing.
Thank you.
You made a note, okay. Earlier, you indicated that Advocate Ramsamy prepared the section 2813 application.
Correct.
We don't have a copy of that application. Are you able to provide one?
May I just check with my Advocate Marga if they didn't ask for the section 2813?
No, we hadn't requested it in the subpoena. It's not one of the subpoena documents. So I'm saying, now that you reference it, are you able to provide us with a copy? So then if I understand your testimony, you give an instruction to Advocate Ramsamy and the Section 27 affidavit.
Correct.
And you want Advocate Ramsamy to make an application back to you in terms of Section 2813. Please explain how that works.
I have applied my mind to the Section 27.
Yes.
But I have to give it to a team to also apply their mind and to see whether or not an investigation can be instituted. I took the view at the time that it fell within the mandate of Idac. But in terms of the prescripts, no investigations can happen if you are unable to comply with an application for an investigation. So we hand it over to the prosecutor, who must look at the 27. She didn't have to apply for a 2813. If she then, after having assessed it, decided it does not fulfill all the requirements. It is consider this matter, and if you agree that it falls within the mandate, we're all lawyers to apply our minds, then please lodge a Section 28 application. She decided to lodge a Section 2813 application.
You said the first part, you give it to the prosecutor and ask her to apply her mind to the Section 27 affidavit, and then express an opinion to you, and then thereafter she lodges an application. Is that correct?
Instead of an opinion, if you agree that it falls within the mandate, you then apply for a Section 28.
Okay. Where is that? Was that your instruction to her? Here is a Section 27 affidavit. Consider it. If you agree that it at least discloses a basis for a preliminary investigation, please provide me with a Section 2813 application? Is that more or less how
A
it
Section
goes?
28 application,
Is
yes.
that how it normally happens?
That is how I recall it happens, yes.
Did its Advocate Ramsamy ever express a view to you on the content and depth of the Section 27 affidavit? Did she ever express her views on that affidavit?
No, when she brought the Section 28 application, I realized that she agreed with the contents of the Section 27.
And she never expressed a different view that it's deficient, it doesn't comply? No, she didn't?
No.
She also didn't pick up the fact that it doesn't comply with Section 27?
No.
She didn't. You, commissioners, yes, please go ahead.
This application, it's made in terms of what? Because my reading of 13, and it may well be that there's another section to read before I get to 13, but my reading of 13 seems to contemplate that you, for example, upon receipt of that Mr. Adams Section 27, if you determined on the face of it that it is necessary to hear evidence, you would proceed to instruct that such a process should happen. Where do we see that Ms. Ramsamy had to make an application before that inquiry, that hearing of evidence could be held? I wouldn't have a difficulty reading 13 if you said, I looked at this affidavit and determined that we need to hear more, and then I authorized a preparatory investigation. I wouldn't have a difficulty with that because I read 13 to empower you to do that. But you speak of a more involved process where you make the determination that this falls within our mandate, you give it to somebody else for their opinion and execute, and then you say to them, if you think we must do a preparatory investigation, bring that application, and I'd like to see where is that contained. That's the...
So I take it, Commissioner Baloy, from the section that I had referred to, which was the Section 28:13, if the investigating director considers it necessary to hear evidence in order to enable him or her to determine if there are reasonable grounds to conduct an investigation in terms of subsection 1A, the investigating director may hold a preparatory investigation. That is where we take it from.
No, I'm not questioning that you could convene the hearing of evidence, or you can convene a preparatory investigation or hold a preparatory investigation. I'm not taking quarrel with that. I accept that in terms of 13, you have the power. I'm just trying to understand this process that you've just described to Ms. Sillo, where you get the Section 27, you look at it, you make a determination that it falls within what is raised there, falls within your mandate, so you should investigate. And then you give it to Ms. Ramsamy, you give it to the team, I assume at that point, to execute. But I understood you to say to Ms. Sillo that in that discussion with Ms. Ramsamy, you said to her, look at it, if you think it's necessary to hold a preparatory investigation, make an application. That's what I understood you to say.
Look at it and see if it is necessary to make a Section 28 application.
Yes. Then my question is, a Section 28 application in terms of what? Is this a practice? Is this one of those where in your office you have ways of doing things? I mean, you have encountered these subsection 13 many times. So if it was in the Act, I think if that requirement to apply to you. If it was in the Act, I would have expected you would go straight to it because it's something that you encounter every day. If you are not able to find it, can we conclude that this is one of those instances where you practice things, you have ways of doing things, they're just not written down?
That are procedural, based on the requirements of what would initiate an investigation.
Yes. So it's not written down anywhere. You just have a practice in the office.
It is a practice, yes.
Thank you.
Both 27 and 28. So if you look at the main body of 27 and 28.1, because those are the two sections that take you to 28.13.
Yes.
For you to determine that what is reported to Idac falls within your mandate, there must be a reasonable suspicion or reasonable grounds to suspect that a specified offense has been committed. So in what was presented to you, what is that specified offense that you looked at and then said this falls within our mandate?
In terms of the 27.
Both 27 and 28, because that's where you start.
Yes.
Chair has engaged you on the test, subjective, objective. We've moved past that. Something further must exist, and that is a suspicion that a specified offense has been committed or is being committed, or there's an attempt to commit such an offense. So what is the specified offense here that made you believe that this falls within Idac's mandate?
It would have been where the procurement portion was. It was contraventions of PFMA and or fraud, where the siphoning of the monies and or that was the theft and the financial crime with the money laundering aspect, and where the issues of the vetting and the appointments, it was in the way that it was couched, the capture of those systems and processes.
So are those specified offenses as contemplated in 27 and 28?
Those are the offenses as set out in Section 7 of the Act that set out the offenses that Idac falls within Idac's
no, that's
mandate.
a different question. 27 and 28.1 do not say any offense unless you read specified offense in 27 and 28.1 to mean any offense referred to
in Section 7.
In Section 7. Is that how you read it?
Yes. Because we have no other offenses. That specified offense is the one that was deleted. They didn't.
So let's just be clear then. So your determination was that because these offenses are offenses referred to in Section 7, sub 1, capital A, that is good enough.
Correct.
Even if they are not specified offenses as contemplated in this statute.
Yes,
as far as you were concerned, you still had a mandate to investigate them.
That is correct.
And that was your understanding.
Correct.
Okay.
Thank you, commissioners. And you then subsequently received, I take it, the Section 28.13 application from Advocate Ramsamy, and then you authorized the preliminary investigation.
That is correct.
On the 6th of December. And prior to your authorization, is there any investigation that Advocate Ramsamy or member of her team undertakes? Or does she apply her mind to the Section 27 affidavit and perhaps the law, and then drafts the application in terms of 28.13, meaning she doesn't seek to obtain documents extraneous to the affidavit?
Correct.
So she works purely on the affidavit?
That is correct.
And forms a view?
Correct.
Okay. And now, this morning, as I think Mr. Bodrani indicated, documents were forwarded to the Commission as part of the subpoena requests made. And these have been received, we confirm. In a moment, we'll be turning to them. Yes, no, I hadn't. I said I will be referring you to something. The commissioners will recall that this morning I referenced documents that were requested. Yesterday I indicated that they had started trickling in. Advocate Johnson read off some documents she had at hand, and she indicated that they've been provided to us. And Mr. Botlani confirmed that. The documents have been received, and I'd like to, they should be included in your files. I pray they are. We are now in file 8. And I'm interested in particular.
Should we put away those we were using this morning? Or not really?
Judging
Not
by the time, yes, I think so. Considering we're ending at 3, yes.
Well, there's quite a clutter in front
I
of
can
us.
well imagine. I apologize. Yeah, except for the file containing the referral affidavit, file 2, page 512. Thank you, Chair. Thank you, Commissioners. In particular, I wanted us to go to page 3282. That is the authorization in terms of Section 28, sub 13 of the NPA Act. Advocate Johnson, I need us to put a finger on that page and that file. Please don't close it. And let's go back to the referral affidavit. That would be file 2, page 512. Now, in this affidavit, I note at paragraph 2.
Sorry,
512 of file 2. Help is coming.
This is file 2. Why do we not have a...
Page 512.
I don't know why.
The referral affidavit.
Yes, I had given the file back. I'm not sure why I'm not seeing it.
Did you perhaps, because of the clutter around you, did you take it out of the file?
No. No, I didn't take it out of the file. File 3.
May I request your counsel to, I don't know how many copies they have available of the referral affidavit, page 512 of file 2. And for your purposes, Mr. Botlani, we will be flighting it, so you'll follow it on the screen, if you could. Thank you so much.
Just thank you, Council.
My pleasure, Member. Now, if we go to paragraph 2, on this affidavit, I see concerns regarding General Kumalo, General Lushaba, General Madondo. You see that?
I see that.
And overleaf at paragraph 4, that's the suspicion regarding manipulation of procurement processes. At second sentence of that paragraph, I see it says, I suspect that General Kumalo and other senior officers in crime intelligence, including Madondo and Lushaba, were manipulating procurement processes to appoint and promote certain members. You see where I'm reading?
Yes, ma'am.
If we drop further down in that paragraph, fourth line from the bottom, once again, it speaks of persons being appointed to strategic positions, and that such persons are suspected to be loyal and close to Kumalo, Lushaba, and Madondo, and those close to them. I go over leaf at 5. I see reference to General Kumalo, where an allegation is made about the former Minister of Police, Minister Cele. And as we know, paragraph 6 concerns General Lushaba and the theft that occurred at his home. Paragraph 7, once again, it's Kumalo, Lushaba, and Madondo. And I think that's about, then we get to paragraph 8 and 9 and 10, which are concluding paragraphs of that affidavit. You confirm that?
Correct.
Now, this is the same affidavit that Advocate Ramsamy was armed with.
Yes.
Now, let's get back to our file 8, page 3282.
Got it.
Now, at 3282, that's an authorization signed by you. If you look at 3283, dated the 6th of December, 2024.
Correct.
And in the first page, you say, I, Andrea Johnson, and you continue regarding your authority. And you indicate that you have reason to suspect that the following offenses have been committed, and you list them. Am I reading your authorization correctly?
Yes.
So these are all the offenses?
Yes, all the possible offenses.
Possible offenses.
Yes.
And you clarify that over leaf at 3283, where you state that these have been committed or are being committed, or attempts have or are being made to commit such offenses in an organized fashion by inter alia, the persons or entities in the annexures to be the institution of the investigation in terms of section 2813 of the Act in relation to the activities of South African police services and crime intelligence and any other entity. My question is, that conclusion you draw, that litany of crimes has been committed or being committed or attempts have been made, that can only derive from the Section 27 affidavit.
Correct.
What in the Section 25 affidavit leads you to the conclusion that the crimes listed in there, all or any, have been committed or were being in the process of being committed?
The Prevention and Combating of Corrupt Activities Act falls within the ambit of the allegations in paragraph 4.
Paragraph 4,
Yes.
noted.
Not knowing what all would have happened in the alleged placement and appointment of persons. So it couldn't rule out the corruption. The Prevention of Organized Crime Act would relate to paragraph 4 and likely points to the laundering of money out of crime intelligence.
Yes.
The National Strategic Intelligence Act would relate to the vetting issues.
Okay.
And the Secret Services account relates to the allegation of sorry. Paragraph, at the end of paragraph 3, the use of secret funds. And then there is the further allegation in paragraph 5, some of the funds became taken unlawfully from the secret funds account. So wherever there was a relationship with the secret funds account, that act becomes applicable. The procurement fraud, the alleged procurement fraud under the Public Finance Management Act, the Financial Intelligence Center Act also relates in part just want to get to paragraph 7.
Yes.
And then the contravention of the Police Act because of the appointments and the vetting that is referred to. And then the allegations of fraud, theft, forgery and uttering and or defeating, obstructing the administration of justice, which would relate in part to, not in part, in the main to the charges against General Lushaba.
Okay. Now, what would be the theft? What would relate to the theft here?
The theft was the actively siphoning money from the Secret Service account.
Okay.
And then there was the one...
and the forgery and
I
uttering?
suspect that funds became taken unlawfully from the Secret Service funds account under paragraph 5.
Thank you. And the forgery and uttering?
That would have been in relation to manipulating of the procurement processes and processes for the appointment, that there could be allegations there of forgery and uttering.
How do we start with manipulation of processes and then we suggest that there was forgery or that manipulation involved forgery? Because the process could have been manipulated in so many different, 1,000 ways. How do you land on forgery and uttering?
It is a possible offense.
Okay.
Yes. No. So perhaps, if you would allow me to just say, is that these are the offenses that one is looking at. They are not open nor are they limited in terms of you go with what you have, but if you don't put in the possibility, usually when you have fraud and or theft, there often does happen to be forgery and uttering. And so if you haven't listed that offense, it might become a challenge later on.
So this is a list of all possible crimes
within the ambit of the 27.
Of the 27?
Yes.
And you so maintain?
Yes.
Okay.
Please define forgery.
It is where, in terms of, for example, with the documents, that someone would have forged someone's signature either in the procurement documents, in the appointment documents, or in the vetting documents. It purely relates to the forgery in terms of putting in.
And there was a basis for suspecting that this had a reasonable suspicion that this had happened?
reading it in its totality.
Would there be a reasonable suspicion that this had happened?
Correct.
On what basis?
That if
Is there anybody who ever suggested that documents had been forged? For example, that certain people had signed documents purporting to be other people?
that has come afterwards in the investigation, yes.
Yeah, the question is at
In
this
this instance,
point when
yes.
you're writing this document,
Yes, that,
what were you relying on to get to the point where you say forgery and uttering is implicated?
I read it, Commissioner Baloy, in paragraph 4, where we talk of the manipulating of procurement processes and processes to appoint and promote certain members to higher strategic positions within the crime intelligence. That in that manipulation, there can be fraud, forgery, or uttering.
Speaking for myself, I don't see how that takes you to forgery. Remember, you said in the introductory part, before you itemize the offenses you referred to, you have said you have open quote reason, close quote, to suspect. I don't see the reason for you to suspect in what you've said thus far. I just do not.
I take your point. This is what I've got.
Thank you. Thank you.
Thank you, commissioners. Then just to conclude, at 3283, having then itemized those crimes, you say those offenses are being committed or have been committed by, I'm reading the second line, persons or entities in the annexure. Now that annexure appears at 3284. Overleaf. That's the annexure. Now, we have General Kumalo, the General Madondo, General Lushaba, and a list of others. I know, as I indicated to you, that the Section 27 affidavit specifically identifies General Kumalo, General Madondo, and General Lushaba. We just did that exercise at the various paragraphs 2-4. I cannot find in the Section 27 the persons identified under items 4 to 12. And you recall that your testimony was all you had at the time was the Section 27 affidavit. Does not reference any of the people listed from 4 till 12. Where does your annexure get them from?
Johnson, I think the question is, who gave you these names? They're not in the affidavit. We can look at it for the next hour. You will not find the names in 4 up to 12. Somebody gave them to you. Who gave you these names? And under what circumstances?
This application came to me from the prosecutor.
So Ms. Ramsame will have to tell us where she got these names from.
That would be correct.
Okay.
Did you inquire from her where she got the names from when you know that you only gave her the Section 27 affidavit and you are quite familiar with it?
Yes.
Do you engage and say, who are these ones now? Where do they come in? How do they come in? They are not in the affidavit. You are not conducting an investigation yet, so you are not obtaining your own evidence. Where do these names come from? Did you have that engagement with her?
I didn't have that.
Why not? Shouldn't you have? Because from what you are suggesting, it's like she looked at those 3 names and said, no, 3 is not a good number, I prefer 12. And start like somarhoying other names in there. And you signed, and you are happy with that. How come?
As I indicated, according to me, she only had the 27.
Yes.
And she would have then put together the 28.
Yes,
Yes,
which we're looking at.
yes,
And you know the 27 doesn't contain the names from 4 to 12.
that is correct.
So why do you sign it in the form that it is, where suddenly it includes a litany of other people who are not mentioned in 27 affidavit?
Brigadier Mokwele is there. Sorry, Council, you refer to only the first four?
The first three.
First three.
The first three.
Yes.
And sorry, Commissioner Baloy, that I'm now a bit slow. I don't intend taking the whole afternoon to.
Well,
So the-
I'm just trying to be helpful.
I know,
because
I'm trying to figure out how she would have arrived at the names because their official capacities mentioned, but the names are not mentioned. I take the point.
you accept that it is not from the
27.
Section 27
Yes.
affidavit that
Yes.
she got the names.
Yes.
You accept that someone must have, if they come from her, someone must have given her these names.
Correct.
Yes.
And I will find out.
And you accept that at this point, when she approaches you with this application, the investigation hasn't started yet. You
That is-
gave her the affidavit, she looked at it, and she came back to you
That is
and said, we need to have a preliminary investigation. So you accept at this point, there's no investigation yet.
Correct.
All right, thank you.
My challenge is this, Advocate Johnson. You are authorizing an investigation into 8 people who are not mentioned in the singular document you have. They are not referred to you. There's no complaint regarding them. But you are authorizing an investigation into them. In terms of what section are you acting in so doing?
A conversation must have happened
With who? That's a question.
with Advocate Ramsamy.
No, she's not conversing by her soul self. Who is she conversing with?
What I'm saying is she and I must have had a conversation.
Oh, so you are aware of
I'm
them.
saying she and I must have had a conversation, and I will follow that up because I don't have an independent recollection of a conversation. And she would have to indicate then if she had a conversation with somebody else. I wouldn't just have blindly signed it without finding out from her.
Did you perhaps suggest these names to her?
No, these are not people I know.
Can I say the difficulty is that you don't seem to abide the terms of this Section 27. Even if she proposes the names to you, you are the final decision maker. You are the in charge. You are the one that's authorizing an investigation. It's difficult to conceive of a situation where she comes back to you and she gives you a list of names and you don't say, no, we can't do that because it doesn't arise from this affidavit. We haven't started an investigation, so I know you didn't get those names from an investigation. I know you didn't do that. We have at this point only this affidavit. And you don't say, we are obliged to work with what we've got. We can't do whatever we feel like. It's difficult to understand that you would be party. If this is her giving, she gave you these names, that you are happy to sign off a truly invasive investigation because your powers to hear evidence means you can call these people, you can look into their affairs. That's what it means. And you do it outside the corners of the only document you have on which you could work with. You, the head, are not in a position and you do not say to your prosecutor that we are not doing that. We are bound by law, we are bound by rules to investigate that which is properly given to us. It's a misuse of powers, whether it comes from her or from you. At this stage, this is a misuse of powers. to take intrusive steps and action against people on this affidavit. You have no justification whatsoever on this affidavit to be looking into Likalakala, Ngube Moyani Sibula, Madileng, Mokwele even, by name, Duvalo, whoever is automotive engineer. You have absolutely no legitimate and valid basis to look into them. Maybe there is something to look at later on, but we are still at this affidavit stage where you are authorizing that they be called in, that their affairs, their bank statements be looked into, and their lifestyles and everything and about them. And they must come to interviews under threat of, if you do not cooperate, it's a criminal offense. You're happy to do all of that, when in fact the document, the only document on which you rely to act as you do in this document, doesn't create a basis for it. It's to me, it's yet another instance where you, in particular, have misused your powers to go where you are not authorized to go. There's no legitimate basis to do this. Do you want to comment?
I have no comment, Chair.
Thank you.
Advocate Silo, you can clarify it, or Advocate Johnson can clarify it. Maybe I'm too slow now. Before this authorization, I thought there's an application, then the authorization, or does the application come after? Or maybe you can answer.
Yes,
I had understood that what should precede this authorization is an application.
That is correct.
Then this authorization authorizes the application.
That is correct.
Now, can you show us where that application is? Because it may be that the questions you are being asked, the names were in the application.
I say that it's not part of, I don't see it here. And I will ask that they make the application available.
Okay.
I'm not sure why the application is not with the authorization.
The one that I see here, I suspect you're going to be dealing with it later, so I don't want to go
Yes,
there.
that's a different authorization
Yes.
now. Yes, it's not the 2813 authorization. Thank you. Chair, it's 1502, as I'd indicated.
Let us adjourn and resume at 9:30 tomorrow.
Thank you, Chair.